Hello everyone. Now we have reached to part three of this constitution, that is fundamental rights, and I tried to set up this new screen sharing with you. I hope you like it. Now we have reached Article 12, definition. In this part, unless the context otherwise requires, the state includes the government and parliament of India and the government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the government of India. Note. And believe me, these notes are as good as they can get. And yeah, these are the best notes for judiciary, for CLAD, for UPSC, and it's given in a very comprehensive manner. You can get it through this Bare Act of Ambition publication. That is the coaching of judiciary in Delhi, the Constitution of India. Okay, so the note here is the term state as defined in Article 12 for the purpose of Part 3 Fundamental Rights of the Constitution includes the following: the Government and Parliament of India, Executive and Legislative Authority of the Union, the Government and Legislature of each state, Executive and Legislative Wing of the state, all local or other authorities within the territory of India, all local or other authorities under the control of the Government of India. And yes, it's not working. Okay, in University of Madras versus Shantabai, AI 1954, the Madras High Court held that other authorities could only indicate authorities of a like nature, that is, adjustem generis. If so construed, it could only mean authorities exercising governmental or sovereign functions. It could not include a person's natural or jurisdict, such as university, unless it is maintained by the state. In Rajasthan State Electricity Board versus Mohanlal and others in 1967, the Supreme Court held that the expression of other authorities is wide enough to include all authorities created by the Constitution or the statute on whom powers are conferred by law. It is not necessary that the statutory authority should be engaged in performing governmental or sovereign functions. Modern concept of state in Sukhdev Singh versus Bhagatram, AIN 1975. In this case, Justice Matthew preferred a broader test and gave a modern concept of state and talked about the agency and instrumentality of the state. The modern concept of state given earlier in Justice Matthew was finally summarized by Justice Bhagwati in R.D. Shetty versus International Airport Authority of India, AIN 1979. In this case, it was held that if a body is an agency or instrumentality of government, it may be an authority within the meaning of Article 12, whether it is a statutory corporation or a government company or even a registered society. In Ajay Hasia versus Khalid Mujib, in 1981, the Supreme Court laid down the following tests for determining whether a body is an agency or instrumentality of the government. These are the factors of a state according to Supreme Court. Number one, financial resource of the state is the chief funding resource. Existence of deep and pervasive state control. Functional character being governmental in essence, that is, if the company, if the functions of the corporation are of public importance and closely related to governmental functions. Fourth, if a department of government is transferred to a corporation. Fifth, whether the corporation enjoys monopoly status, which is state conferred or a state protected. The court said that these tests are not conclusive and clinching but illustrative only and will have to be used with care and caution by the court. These are not conclusive but only illustrative, which means more factors can be concealed into. And private educational institution, whether state or not, as you can see the tick mark, it is not a state according to in Uni Krishnan versus State of Andhra Pradesh. The Supreme Court held that a private educational institution, either by recognition or affiliation to the university, could never be called as an instrumentality of the state. A private educational institute can never be called an instrumentality of the state, whether NCRT is a state or not, and whether NCRT is a state or not. And Chandra Mohan Khanna versus National Council of Educational Research and Training, that is NCRT, AIR 1992, the Supreme Court of India held that it is an autonomous body and a registered society, and mere state control does not render it state under Article 12. In order to come under the purview of Article 12, a body must be pervasive under pervasive control of state. And according to Supreme Court, NCRT is not under pervasive control of state. Whether CSIR is a state or not, in Pradeep Kumar Vishwas versus Indian Institute of Chemical Biology, 2002, the Supreme Court held that CSIR, that is Council of Scientific and Industrial Research, is an instrumentality of state falling within the scope of Article 12. And whether BCCI is a state or not, that's an interesting question for all the cricket lovers here. And BCCI is not a state, as you can see from the tick mark. In Board of Cricket Control of India, Board of Control for Cricket in India versus Cricket Association of Bihar, 2015, it was held by Supreme Court that the Board of Control for Cricket in India is a registered society and not a state within the purview of Article 12 of the Constitution. And the last and not the least, judiciary, whether state or not, in Raju Prasad Sharma and others versus the state of Assam and others, 2015, the Supreme Court held that judiciary of India in India acting on its judicial side cannot be considered a state under Article 12 of the Constitution, and that only when the courts deal with the employees or act in other matters purely in administrative capacity, they may fall within the definition of a state for attracting state jurisdiction. So very cleverly in this case, Riju Prasad Sharma versus the state of Assam, Justice Markandeya Kaju, I believe, he, for the sake of acting on the judicial side, it is not a state, cannot be considered a state, while performing the administrative duties, administrative capacity, and attracting employees and dealing with the employees, it is a state. So they took the power and excluded the responsibility, and it was a very clever judgment by Justice Markandeya Kaju. Okay. Mm, I guess it will get over with this.